Greetings and welcome to today's webinar titled Estate Planning, the Big Four. So as not to confuse, the Big Four is not in reference to the Big Four accounting firms or the Big Four nations. Rather, the Big Four estate planning documents that are commonly found in a well-planned estate. One of my law professors many years ago shared this statement that has stuck with me ever since. You know, we all have an estate plan, either one made by you or one made by the state. And fortunately, we get to choose to make a plan. If you're listening in today, I'm going to assume that you understand and appreciate the need for estate planning. Estate planning, as you can read on the screen, is a process designed to ensure that an estate is efficiently and accurately transferred to those individuals and organizations the estate owner cares about the most. Wow, that's a mouthful, and boy, is that boring. You've probably heard statistics that most of us tend to procrastinate when it comes to estate planning. Understandably, it's not always the most pleasant thing to think about. But very important for us, very important for our families to make sure that we're planning. So in our short time together, we'll provide some insight into the four most common legal documents, including wills, living trusts, durable powers of attorney for finances and healthcare. And most importantly, we're gonna try doing that and avoiding legal jargon as much as possible. But first, I think it's important to provide some context. So I want to briefly review the current estate tax environment. The current reality is that very few people will be subject to the estate tax. Over my career, I've witnessed the estate exclusion. That's the amount that you can transfer to others, go from about $600,000 to now over $11 million. Additionally, a married couple can pass double that or 2 times the $11.18 million. So the reality is most of us are not going to be subject to estate taxes. Another point that I'd like to make is you may be familiar with what's called the annual exclusion. For many years, it was $14,000. That's been increased to $15,000. On the screen, it says per person, but it really should say per recipient. So a husband and wife could both give, let's say, their daughter $15,000 each or $30,000 total. So most of us don't have to worry about estate taxes, but we are going to have to deal with income taxes. And fortunately, there's some relief via a step up in basis for taxable brokerage accounts, for example, or even homes. When someone passes away, they receive a step up in basis. As an example, let's say I had a stock portfolio worth $200,000 that I paid $50,000 for over the years. Well, that $150,000 goes away because at death, I get to step up the basis to the full $200,000. Also with IRAs or other type of retirement tax deferred accounts, if planned correctly, we can help beneficiaries stretch out the income tax liability, making a little bit easier. These are two important areas to be thinking about, and also get with your financial planner to make sure you're applying it to your own situation. So to recap, estate planning today is about making a plan, a choice that you're going to make to ensure that your estate goes to whom you want, when you want, and how you want it. And for most of us, the focus is on income taxes rather than on estate taxes. As a certified financial planner practitioner and attorney serving clients the last roughly 25 years or so, I've had the privilege of working with clients to implement sound estate plans. It's a lot of fun. It can be tough work and not always the easiest, but at the end of it, clients are in a much better place, and it's a privilege to be able to work with clients. All of our center planners are well versed in the estate planning area. Additionally, we work with many of the area's finest estate planning attorneys And if your situation calls for a referral, please let us know. We'd love to be able to help you out. If you have any questions after this webinar, please feel free to email me. With all of our webinars, due to the securities regulations, please note that all chat features with this webinar have been disabled. Also included our website for later reference. The first of the big four is the last will and testament. Now, one of the common misconceptions is you don't need a will if you have a trust. Is that correct? Well, that's not correct. Normally, all real property and investment assets will have been transferred to your living trust. Therefore, the only assets to be disposed or go through your will are usually furniture and personal effects, tangible personal property. However, even with good planning, sometimes there are assets that are just in your name at death, and that means we have to have a will. So your will, referred to as a pour-over will when you have a trust, essentially says, hey, pour over any assets that are not already in my trust, put it into the trust at my death. I'll pour it over. You might even think of a will and living trust working like belt and suspenders. Your will also is the place where you get to name a personal representative and even a successor personal representative. This role used to be called the executor, and I like to joke that the legal profession wants to always stay one step ahead, so once people caught on to the term executor, they changed it to personal representative. But they're really the same duties. The personal representative is the one who assembles and inventories property. They pay your debts, they pay funeral expenses out of your estate, and ultimately file estate and income tax returns with the help of other professionals. The will is also a place where you, if you have minor children, you'll name a guardian or appoint a guardian in the will. This is the person that is to care for any minor children. I like to say it's the folks who you trust to raise your children in a manner consistent with how you would have if you were here. Additionally, this person would work closely with the trustee to ensure that there's sufficient resources, there's money available for the guardian to care for your children. The second document in our big four is the revocable living trust. Well, let's break that down a little bit. So revocable means you can change, amend, tear up, you can delete. This is at your discretion. You can do whatever you want with it. Living, as you might expect, is exactly that. Yep, you're living, right? So the question becomes, what can a revocable living trust accomplish or do for you? First, the revocable living trust can help avoid probate and conservatorship proceedings that can be expensive, right? They can take time and they're public. So a lot of folks want a private manner or private process, and that's where a trust can help. And that just means there's no court proceedings, there's no public record, no one has to know your business. Now, when you pass away, you name a successor trustee rather than having the court appoint a trustee. And this is the person who ultimately distributes your assets as you intended to your spouse, your children, or grandchildren. Now, if you are married and you may have trust now, each of you may have your own current trust, you're going to want to review your plan given the new exemption amount I mentioned earlier, that roughly $11 million figure. So many of you have trusts that essentially say when one dies, your estate is to be divided into two trusts or two pieces. So let's explore that a little bit and try to make some sense of it. Many existing trusts state upon the death of the first spouse, the trust of the deceased spouse is split into two separate trusts or two pieces, as I mentioned. Historically, this is what provided the mechanism to shelter the $11 million from estate taxes. So this first trust that was created is the so-called credit shelter trust. And this trust is funded up to $11 million of property, right? Which for most of us is the entire estate. Now, the good news is the surviving spouse receives all the income from the credit shelter trust for their life, and the trustee, which is usually the surviving spouse, can pay any amount of the trust assets required for his or her health, maintenance, and support. All right, these are called the HEMS. Next, upon the death of the surviving spouse, all of your property is distributed from that credit shelter trust to the benefit of your children or any other beneficiary. Now, this ultimate distribution may be an outright distribution, or you may choose to only make those distributions at specific ages or events, however you'd like to do so. But the key here is we find that this distribution scheme, if you will, is not what most clients intended. Most clients never meant for their entire estate to be locked up in a trust for their spouse. So many clients are reviewing their plans with their estate planning attorneys and considering a joint trust or another distribution scheme that feels a little more like joint property. Now, a quick aside on leaving money to children, really no matter their age. Consider distributing money over 2 or 3 time periods. For example, with younger children, you might consider a common distribution scheme such as a third of the money at age 21, another third at 23, and the remainder at 25. For adult children, you might consider providing half the money immediately, but waiting another, say, 5 or 10 years for the second half. And really, with a trust you control, you can be as creative as you wish. The third document is the durable power of attorney for finances or property. Now, this document will allow you to name someone else, such as your spouse or an adult child, to manage your assets and personal well-being in case you're unable to do so due to serious mental or physical disability. Again, having this document allows for privacy and eliminates the need to go before the probate court. You can elect to have this power become effective immediately or only upon written certification of 2 physicians. That's the springing power, meaning the power for someone to act doesn't spring until we have the written certification of 2 physicians. For those of you who have unmarried adult children, especially college-age kids, you might consider having them also set these kind of documents up. It'll be easier for you to transact business with a college, for example, even a bank if you need to help them out. The last of the big 4 is the healthcare power of attorney. And this durable power of attorney for healthcare decisions can be used to assure that your final illness will be treated, in a manner consistent with your wishes. And through this durable power of attorney for healthcare, you get to designate a patient advocate who will make medical treatment decisions if you're unable to do so. Now, many times people think of this as the pull the plug document, and it certainly can be, but it covers any medical decision made on your behalf if you're unable to make decisions. And there's even a fill in the blank if you were to go online and look in the state of Michigan, for example. The state bar has a nice fill in the blank form. Also, many hospitals these days do a really good job at asking if you have this document in place, and most of them will also give you a form document if you don't have one already in place. Asset titling or beneficiary designations are technically not part of the big 4, but are critical to successful planning. I've witnessed too many times where folks spend time and dollars on the documents but fail to actually fund their trust. And this only makes for some expensive paper. Your attorney should help provide counsel in this area, and our planners and entire team can be of great help as well. It's something that we do on a daily basis. Generally speaking, taxable investment accounts, bank accounts should be changed to name your trust as the owner. IRAs and other tax-deferred accounts, the ownership can't be changed, but you can change the beneficiaries to be consistent with your estate planning documents. And in many times, if you're married, because of the income tax benefits, you would name your spouse as the primary beneficiary and then name your trust as the contingent beneficiary. Again, very important to make sure that you're funding your trust, you're changing titles, you're updating beneficiary designations, and make sure you're working with our team and your attorney to make sure you got all the I's dotted and the T's crossed. Before I conclude, I want to share a very helpful resource that is on our website. Our personal financial record system and letter of last instruction really provides a great roadmap. If something were to happen to you, this document contains not values, but provides the roadmap for those you leave behind, saying, you know what, here's my attorney's contact information, here's my CPA's information, here's where I bank. If I have a pension, for example, here's the employee benefits contact. I have found that it really helps your family out and answers probably the first 25 questions or so. That's really critical in a time of crisis, would be really helpful to them. I want to thank you for listening in. I encourage you to reach out to our team for additional information, especially as it relates to your unique situation. We all have a unique story, and we want to make sure that the planning is customized to your personal needs. As comprehensive financial planners, our goal is to help you make sound financial decisions, and certainly estate planning is an important area that we can help provide some value. And remember, everyone has an estate plan, one made by you or one made by the state. So protect yourself, protect your loved ones, and thanks for listening in.